present. We are outside the presence of the jury. There's an issue before the court regarding the necessary foundation for the testimony of the child. Who would like to speak to that?
I can speak to that, Your Honor.
Go ahead.
I think that the defense and I, we're largely on the same page. I think the matter before the court at present is a question of law under 403. We're not opposed to presenting these witnesses on this limited basis as far as the foundation for Ada's potential testimony outside of the presence of the jury, to allow the court to consider that in making its decision. I would imagine that maybe a number of the issues, if she is allowed to testify, a number of the issues that would be explored might also be explored in front of the jury at a later time. But I think it would probably be appropriate to have it heard simply by the court initially.
Let me ask, is there, as I think through this, are the child's answers to questions put to her by various people relevant to the foundation, or is it just the number of times she's been spoken to?
I think it's the number of times spoken to her is what reflects on the issue of taint and bias. I mean, her answers are her answers.
If they change over time, does that go to the constitutional reliability of her testimony?
It may, and I think there's an issue of whether she was maybe understood correctly over a time, if there have been changes.
Mm-hmm.
But I think that could possibly be in play.
So her answers would be relevant to whether her memory has been influenced, but also to the issue of whether she understood questions posed to her.
That's correct. And I even think on the listener's side, Judge, if someone posed a question to her and she talked about the event, was the listener accurately understanding what she was trying to express?
Mm-hmm.
That's part of it as well.
Okay. From the defense. I'm sorry, were you finished?
And I was just going to add that we discussed the timing of this, and we'd like to do this probably Thursday morning and possibly have the jury come in a little bit late so that they're not seated here waiting for us to do something.
Could we take advantage of 3 to 5 each day?
We brought that up. The only hesitation I have is one of the witnesses is Doug Whitney. He's currently a commissioner, and we're having a difficult time finding an available time for him to come in to testify. We also have the issue with Alexis. Tomorrow will be the week anniversary of her giving birth to twins, so we're trying to give her time to recuperate. Even one extra day may be helpful.
I hate to take scheduled trial time to deal with foundational issues if we have 2 hours in the afternoon each day. So
I understand that.
I mean, even I'm not married to what day we do it, but I mean, even if we did it Thursday, when are you thinking of calling the child?
Thursday, if her testimony was admitted.
How long do you...
That's not to say it couldn't be done Friday morning either, though.
Right. How long would you think the hearing would take to determine foundation?
We discussed with the testimony and argument probably 2 hours.
Okay. Anything else from the
That's all I
state?
had.
Appreciate that. Thank you. Go ahead.
Your Honor, we believe that the answers that Ada has reportedly given are material to the foundational issues, and as we set forth in our pleadings, the changing to a degree of her memory And so that's why we feel it's very important that this be addressed outside of the presence of the jury, because we believe that things will be discussed for foundational purposes that ultimately shouldn't be admitted subsequently. And
Okay. I'm sorry, go ahead.
I was just going to say, from the defense point of view, we're happy to cooperate whenever works well with the state, and your honors obviously when in charge. So we'll be ready whenever your honor tells us to.
Can I just ask you a question about the nature of your objection and which rule or rules of evidence you raise the objection under? Rule 601 deals with the issue of competency, and we also have a statute that deals with that. It's 78B-1, 127, and 128. And the statute really gives that broad competency, that definition that I think Rule 601 was intended. Rule 601 intended to get rid of all of the status competency rules of the common law and make any person presumptively competent. And then we have Rule 403, which is the issue in Fulton. And as I read the cases, they basically say objections like the ones you're making ought to be made under 403, really, rather than 601 at this point. But at the same time, the court has a role in determining the competency of a witness under 104A. It's a 104A determination. I have to find a person is competent by a preponderance of the evidence. And so I just want to get a sense, so that I'm clear, on which of these rules, or if all of them, you raise your objection.
Your Honor, I believe all of the rules come into play. I believe that the Fulton factors address primarily Rule 403.
Right.
I believe in addition to the rules that you mentioned, the due process right of confrontation also comes into play, where, as is discussed in the Fulton case, a child's memory can be conditioned such that meaningful cross-examination can't occur. And we believe that that's what has occurred in this case.
So 601, the competency statute, 403, my 104A determination, the due process clause. Anything else I should be aware of?
I think that's pretty much it. Under the due process clause, too, our argument is in addition to the concerns in relation to what we believe is the condition of Ada's memory, this case is separate from many that we see, where it is actually the investigators who, as we perceive it, caused the taint, which further brings into concerns of due process, fair play, and substantial justice.
Why would that matter in terms of the source of, at least as it relates to competency? The issue is that the memory is tainted, or not memory at all. Does it matter who caused it?
I think it does. If you look at some of the, as Your Honor pointed out, some of the cases in relation to multiple interviews of children discuss family members saying this and that, people that wouldn't know better. In this particular case, it was actually the investigators who were part of the prosecutor's office that were encouraging a protocol that is known to cause unreliable results to come from children, and that's very concerning to me.
And I agree that that's concerning, but my question was, does it matter who when it comes to the issue of competency? I mean, the issue is that the child's been talked to by someone, and granted, that someone might matter if it's a family member or a person in a position of authority where the child feels pressure in some way to agree, or, you know, there may be some people who have greater influence over the child than others, and in that sense, the person may matter. Am I understanding that? Is that your position?
Well, no, I think it's a little beyond that. Certainly,
Okay.
The person who is interviewing the child matters.
Okay. In the way that I just
The
said.
way that you just said, because the science behind it is clear that people that are close to the child and have a bias, whether explicitly expressed or implicitly expressed, is known to potentially taint a child witness. And so the person asking the questions does matter. And in this particular case, I believe that beyond that aspect of the matter is the fact that it was the prosecution team, the investigators specifically, that was encouraging this known unreliable process to occur multiple times. And so that's where I believe that the due process clause really comes into play in this case. It's different than the Bear case, where before filing or even an investigation of the case, multiple family members talk to a child.
When it comes to ruling on this issue, as a general rule, if we were dealing with an adult witness, we would generally say, yeah, this person may be vulnerable to suggestion. Any adult memory is maybe vulnerable to suggestion over time, and we generally let cross-examination deal with that issue. As you look at this, when you look at a child, is it just, what makes the child different other than it's that they have an enhanced vulnerability to suggestion? Is that what makes a child different?
No, I think it's a little beyond that, Your Honor. It's that the science supports the notion, and we've submitted a report from Dr. Gregory, but the science supports the notion that a child's memory can be conditioned such that meaningful cross-examination cannot occur.
Okay.
And
that's the issue of it. Just what their memory isn't memory at all.
exactly.
They're remembering what other people have told them, and they can't distinguish.
Right.
So the child will perceive it as memory, but it's not memory at all.
Perhaps a false memory.
Does cross-examination disclose that?
No, it doesn't. With children, when they perceive the memories to be accurate, even though they have been created through this unreliable interview process, then there is no ability to conduct meaningful cross-examination.
Okay, I think I understand. Thank you. Do you wish to be heard on any of those
Judge, I would just
points?
add a couple of things. Number one, the science in all this is very evolving, if you can refer to this as a science. Number two, cross-examination is more about simply asking someone about their memory and testing them on it. Cross-examination includes prior inconsistent statements that can be brought up. There's a number of avenues under which someone's testimony can be attacked, not even just through that person, but through other people as well. And I think that we'll get into that with the court in this hearing here, but we'll reserve argument until we get to that phase.
And I'm just trying to get my arms around it. If we're going to do this on Thursday, I'm trying to get a sense for where you're coming from. And I think that's what I'm going to, is cross-examination is a very effective tool to identify inconsistencies in memory over time. And as a general rule, that's how we leave this to the jury to ultimately reach a conclusion about whether the memory is memory at all, or so the product of suggestion as not to be reliable, and so,
And that product of suggestion can be brought out through a number of other witnesses as well. That can certainly be explored. It can be explored through an expert as well. So there's a lot of avenues under which this could be attacked, as opposed to the extreme remedy of suppressing the evidence entirely.
let me just say and I think it will be helpful to me if we're all on the same page on some cases. As I've thought about this issue, the cases that I'm interested in are State versus Fulton. There's a more recent case called Burke, State versus Burke. And I looked at one called, I think it's Callahan. I'll try to get you the site for that one. I've just been doing some research on this issue. And then there's I think a 2011 or 2012 case called Bowers Trucking. This is a case in which there was a terrible accident between the lonely stretch of highway between Salt Lake and Wendover. A car was involved in an accident, another car hit that one, and then Bowers Trucking truck ran into the accident. The plaintiff in that case, the whole issue is, was the plaintiff competent to testify in the case? And so it raises the competency question and what the court ought to be looking at. In that case, my recollection is the plaintiff really had no recollection of the accident, but then had a dream about it, and after that said, I do recall certain things about the accident. And the question was, were they competent? There's a dissent in that case and the majority opinion, but I think it will help get our arms around it. There may be other cases, but those are some that I've looked at that I think are right on point, and I would be interested in your analysis of how they may apply or not apply to what we're trying to accomplish. Can you help me understand Mr. Whitney's schedule?
I don't have it offhand, Your Honor. I just know it's difficult. He has, as a commissioner, he's nonstop in meetings and different things.
The county commissioner?
County commissioner, elected official. There's 3 of them for Utah County.
And you'd prefer to do this Thursday morning?
That's what we had tried to carve out as far as the time.
Do you anticipate calling the child as part of the foundation?
We hadn't anticipated calling the child foundation.
Do you think she needs to, the reason I ask is, does she understand the oath, the difference between truth and a lie? Does she feel a moral obligation to tell the truth? You know, what does she say about her memory? Are you testifying from your own memory, or are you telling me, you know, what someone else told you to say? Does she have perception? I've looked at the preliminary hearing transcript on those things. It appears that she meets those basic obligations. I know your issue is primarily memory, that she'll say she remembers, but it may not be her memory. But do I need to hear from her directly, even if briefly, on those issues?
We were going to bring her on Thursday, Your Honor, in anticipation that she would be allowed to testify. She would then take the stand, so we can have her here. But I think a lot of that is borne out in the preliminary hearing.
What do you think? Do you want her here on the issue of foundation?
Frankly, Your Honor, I expected her testimony in relation to those matters you just mentioned to be the same as they were at the preliminary hearing.
Okay.
So,
Do you want her available for the hearing on foundation on Thursday?
Your Honor, I don't believe that presence is necessary for that. As we've set forth, we believe that her memory has been conditioned such that there's a high probability of false memories.
So on those other issues of competency, let's put memory aside, but on the other issues of competency, did she perceive something? Does she understand the oath? Does she have personal knowledge? Those things you're submitting on the preliminary hearing transcript.
Yes, I think she'll say the exact same things she did.
Same from the state?
Yes, Judge, I think that's all very well satisfied.
I think I would like to have her available on Thursday morning because I really don't know what the other witnesses will say on foundation. It may be that what the child has to say will matter as it relates to foundation. And so if you can have her available, I also think that she's probably, how old is she now?
She's 12 now.
12? Is there a time of day that's better for her than another? I mean, part of me says that she's probably better at 10 o'clock in the morning than after a long day. She might be tired. And
That's probably a very fair statement.
so look, why don't we do this Thursday morning then? If you can take a look at those cases, I'll be reading them as well. We'll have the jury come in on Thursday at 10:30 instead of 8:30. And we'll just need to work expeditiously. I don't want to have the jury waiting. So how long do you think argument will last? I mean, do we need to start at 8 o'clock instead of?
I believe 8:30 to 10:30 will do it, Your Honor.
Okay. Okay. Is there anything else tonight?
There is one matter, Your Honor. There's a state's witness, the witness the state intends to call named Roma Henry. She worked at the Utah State Developmental Center along with the defendant and Stephen Mickelson, who testified today. What we're dealing with on her is notice and local rule 10-1-403. Which requires that both the prosecution and the defense provide the court with the names of its prospective witnesses at the final pretrial conference. If the court will recall, we had in July, before Your Honor was on this case, we talked about exchanging witness lists and discussed a final pretrial conference. Subsequent to that, Judge McVeigh recused himself, and Your Honor came on board. And we never really had that final pretrial conference. The court did set a motions deadline date of September 13th. I think the parties used that as kind of a deadline for most things. And so on the 13th, the state provided to defense. It's a letter indicating, with a list of the witnesses that we expected to call at trial. In that letter, and I have copies if the court would like to see it, but.
I would if you have them.
Okay. I've highlighted certain portions of it, Your Honor. The first one is that Mr. Grunander wrote this letter, and I notified defense counsel that we would notify him as soon as possible of any changes, if any, to this list as the trial approached. And then on page 3 of the letter, items number 61 and 64 are highlighted to point out that another of the state's witnesses, Gayla Moore, was inadvertently listed twice. That same day, Your Honor, Mr. Grunander submitted to the court the state's notice of plaintiff's witness list. Doesn't have the list attached to it, but it informs the court that the witness list was sent to defense counsel that same day. Again, Mr. Grunander put that the state reserves the right to amend the list as trial approaches. If I might approach, I have that as well.
You received these, I assume?
I assume so.
Okay.
4 days later, Your Honor, on September 17th, defense sent to us its notice of alibi defense, which includes defendant's claim that he was at work on the morning that Michelle died. And as I mentioned earlier, Roma Henry's testimony, the proffer for it would be that she also was at work and ran across defendant that morning. So her testimony, we believe, speaks directly to defendant's alibi defense.
What will Ms. Henry say? Give me a proffer of her testimony.
What's expected is that she was at that morning, the Developmental Center held a safety fair. Other witnesses will testify to this as well. And part of that safety fair involved an awards ceremony, which was being given by the HR department to the Medical Services Department for having reduced their number of work-related incident claims. And among other witnesses, Ms. Henry is expected to testify that she did not see defendant at that safety fair for most of the morning, but that he did show up to be present for the award ceremony, and that he was adamant about having his picture taken and making sure that he was in the picture. So we noted also, Your Honor, and if the court doesn't mind, I'll mention each of these documents and then approach all at once.
Go ahead.
Okay. On October 4th, after the September 13th deadline, again, which I don't think was a formal witness notice deadline, it's just what the parties assumed was kind of the end of the line for most pleadings. Mr. Spencer sent an email to Mr. Grunander indicating that they had left Patty Johnson off of their witness list and that they wanted to add her as a potential defense witness. On October 10th, Mr. Grunander sent an email to Mr. Spencer as we're going through final trial preparation, which I wanted to point out when it comes to the rule. My understanding of that rule is that it's not an ironclad lock you in type of, once you've given your witness list at the final pretrial, you're done. You can't change it at all. It's my experience that as the parties prepare for trial, they come across issues that they hadn't noticed before, things come up, and they realize that they'll have to adjust their witnesses, either take people off or add people. And so that witness list that both parties usually provide at a pretrial conference, my understanding is that's the prospective list that is subject to change, and that the parties would render or would submit those changes as professionalism and civility requires, and not try to hide the ball and surprise the other party. So on October 10th, when the prosecution team realized that Roma Henry was not on its list and Gail Moore was there twice, Mr. Grunander wrote to Mr. Spencer and said that he inadvertently listed Miss Moore twice, and that Roma Henry should have been one of those people that wasn't on there.
Did she testify at the preliminary hearing?
She did not. However, her interviews and her statement to the investigators was part of the original discovery package provided to defense counsel in August of 2012.
Okay.
And then finally, this last Saturday, I myself sent an email to Mr. Spencer indicating that we intended to call Roma Henry, and he indicated that he had some issues with that because it was coming up late, and we I think agreed last night that we'd submit the matter to Your Honor. Oh, one final thing, I won't.
What was Saturday? Is that
This is the 19th.
This is
Last Saturday.
Okay.
Preparing for this week is when that interchange happened. Finally, the state submitted on, I believe, let me double check, I think it was the 10th. Yes, on October 10th, its notice of evidence of defendant's acts and statements. It was kind of more specific but still comprehensive notice of everything that the defendant said or did that we intended to introduce at trial. And on page 6 of that, the state did list that Roma Henry is expected to testify and then put down what we think she'll say.
And it's on the 10th that Mr. Grunander has the contact with Mr. Spencer indicating we inadvertently left this name off our list.
I believe that is true. Yes, that's accurate. So for about the past 2 weeks, Your Honor, the state and the defense have been talking about Ms. Henry. We think that's sufficient notice. I did look up a couple of cases preparing for this, and one I thought was particularly informative. It's State versus, I believe it's pronounced Tiliaya, and I have a site for that. It's 2006 Utah App 474. Some of the statements I thought were relevant from this case.
Is that 474 you said?
474, yes.
Okay.
The Court of Appeals held in that case. Now, in this case, Your Honor, defendant, it was a murder case. Defendant, kind of late in the game, produced 6 witnesses that he wanted to have testify. The trial court allowed 5 of them to testify, but excluded 1. And in excluding the 1, it found that the defense team in that case had purposefully left this witness off of their list, even though they had subpoenaed him and interviewed him several weeks before the trial. They had purposefully left that witness off the list until, I believe the court's language was until after the 11th hour, as a way of surprise or unfair surprise on the prosecution. So the appellate court upheld the exclusion of that witness, despite the fact that it was prejudicial to that defendant's case. And in so doing, it held that excluding a witness from testifying is extreme in nature and should be employed only with caution and restraint. It said that this was a harsh sanction that required justification. It found that justification in the fact that the defense team had deliberately left the witness off until after the 11th hour. And then it did not exclude other witnesses that were added late in the game because it said that there was a legitimate last-minute tactical decision for adding them. Yeah, and Your Honor, here not only was the omission of Ms. Henry's name inadvertent, but after we submitted our witness list, we had the defendant's claim of alibi to which she can speak Another case, an older case, is Barrett versus Denver and RGW Railroad. It's a 1992 Court of Appeals case that held that absent a court order clearly establishing a deadline for the disclosure of expected trial witnesses, it was error to exclude witnesses. And that, I won't go into some of the complexities in that case. I cite that one, I think, merely for the fact that we didn't really have a very clear deadline for exchange of witness lists in this case. I don't think it's going too far, though, even to say that even if we did, that the parties are allowed to adjust their trial strategy and the witnesses they intend to call as their case develops, or as they develop their case preparing for trial. And I think that's contemplated by the rule.
Okay. Thank you, Mr. Perkins.
Your Honor, the first witness list that the state produced was in January of 2013, and Roma Henry wasn't on that list. And as was mentioned, she wasn't called to testify at the preliminary hearing. There were multiple other witness lists presented in between January and up to October 10th. Nowhere did Roma Henry appear on any of those witness lists. There have been a number of additions to the witness list, up to 70 some odd witnesses that the state has noticed up. The defense has spent an extraordinary amount of time trying to prepare for all of the potential witnesses that the state may call. And where Roma Henry had not been identified any time during the year as being a potential witness, to hear about her on October 10th for the first time as being an anticipated witness caused me a fair amount of heartburn. I've tried very hard to research each witness that the state plans to call and to work on preparing to meet their testimony long before, a few days before trial, 5 days before trial, I guess it would be, with a weekend in between. And I expressed to Mr. Grunander when I first heard about that I was very concerned about not having time to reflect and prepare for that witness. After October 10th, the state then had an opportunity to present Roma Henry to the jury as a potential witness, and they didn't do so, either in the questionnaire or in verbal voir dire. And so we didn't have an opportunity to find out if any of the jurors may know Roma Henry. That could affect our ability in selecting a jury and exercising peremptory challenges. Now we just don't know who may or may not know her. And clearly the state had the ability to address that before the jury was impaneled, and they didn't do so. I haven't looked at the case that the state cites, but I suspect that the witnesses that were designated at the 11th hour was likely probably still prior to the jury being selected, so that there was at least an opportunity for both sides to present those names to the jury to ascertain who may or may not have knowledge of those witnesses. In relation to the alibi defense, the evidence that will be presented, I believe, in this case is not just Roma Henry's testimony, but the state also intends to call Melissa Frost. Melissa Frost has testified in the past that it was not Mr. MacNeill's past experience to spend much time at the safety fair. And Mr. MacNeill did spend some time at the safety fair when he received his award. And so Mrs. Henry's testimony seems actually to be more supportive of an alibi defense than disputing it. And so to use that as a justification to overcome the failure to give timely notice and failure to do so at a time when the jury could be advised, I don't think is just. It's easy, I think, for the state to assert that, well, there was plenty of time after October 10th for us to go get prepared to examine Roma Henry. It's not, in practicality, so easy. Speaking as a defense attorney trying to prepare for a trial with many, many, many witnesses, with all of the preparations that are necessary between October 10th and October 15th of the starting day of the trial. I mean, even during the trial, every day I'm working until way late at night to get ready for the next day. And so to assert that I can just simply get ready for another witness, I don't think is a fair statement.
Do you have an investigator?
Not one that's actively doing anything, no. I have consulted an investigator, and I've got an investigator designated on my witness list, but his responsibilities have been, actually all he's done to this point is review the computer information that was provided.
Mm-hmm. So I'm just making a list of how the defense is prejudiced. Walk me through that. Number one, we don't know whether jurors know Roma Henry. 2, you've been unable to prepare to meet her testimony because, I mean, is it true you've had the statements Roma Henry gave to investigators since August of 2012?
I think that's probably true, that was in there. But it's never been a focus because she's never been on a witness list. Wasn't on the preliminary hearing list. She wasn't on the January 2013 list. Wasn't on the June list.
Let me ask you this, had she been on the list, what would you have done differently?
I would have, number one, I would have studied the information that was provided in discovery in more detail. I would have researched to find out what biases she may have in relation to Mr. MacNeill. I would have talked to other people and certainly studied the tens of thousands of pages of documents that have been submitted to us to find other evidence that may help me impeach her and support bias. Certainly tonight, if Your Honor were to allow her to testify, I could go read the statement that she has provided and do my best to prepare, but I don't have the time to go sift through the thousands and thousands, literally over 10,000 pages of documents. Not that it's all related to her. I don't mean to be saying that. They're obviously not all related to her, but there is lots of stuff in this case.
Okay.
And so to expect me to go through all that stuff and have the time to search out meaningful cross, I don't think is fair. I mean, sometimes from a defense attorney standpoint, you may spend 10 hours to ask one good question. And I don't, since October 10th, when I first was informed of this possibility, I haven't had time to spend to prepare to cross-examine a witness that I'd never been informed before was going to be called. Okay. And we think that she should be excluded.
Thank you. Anything further from the state?
Just briefly, Your Honor. I'm sympathetic to what Mr. Spencer is saying, and by no means do we intend to spring this on him or to try to gain some unfair advantage. And that's why, as soon as we were aware, we did let him know. As the court will recall, I'm sure Mr. Spencer will recall also, when there was a question about whether the state would be able to proceed with the child witness or whether our toxicologists were coming in, that was a pretty dire moment for our case. And when we moved to continue in denying that motion, the court correctly noted that trials are fluid things, and trial advocates are required to kind of keep on their toes, take care of issues as they arise, and respond to developments that are unexpected. That's why I think witnesses are routinely traded in and out as trials progress. If Ms. Henry were to be a rebuttal witness, the same would be true. Mr. Spencer would be in the same situation that he's describing now. He'd still have to prepare for her in a way that, it's the same way for us. If he calls a witness that, like Patty Johnson, for example, that was added late, we have to adjust and be nimble and try to figure out how we're going to respond to that without the benefit of months.
Do you have any thoughts about how to deal with the issue of jurors not having been examined in relation to her?
It's not a well-considered or researched thought. It's something that I thought if we were to ask the jurors as a form of late voir dire, if any of them did happen to know her, then maybe she doesn't come in. But I don't know if there's precedent for that. I don't know if the rules allow that.
Would you have any objection to making the inquiry?
Your Honor, Mr. Green had pointed out that we have 3 alternates in case of eventualities like these.
Yeah, but
making the inquiry clearly would deal with the issue of prejudice, at least the first issue of prejudice that you've raised.
Well, maybe not.
Well, they're under oath, they're sworn. You're not suggesting they wouldn't answer untruthfully?
No, I'm not suggesting that at all. But what I'm suggesting is that the state had the ability to do this at the time that we were selecting the jury, and they didn't do it. And so whether the jurors answer yay or nay at this point, it's a very different situation than during general voir dire. And we selected jurors based upon their answers during voir dire and exercised peremptory challenges, If one of them happens to know Roma Henry now, it's possible that a juror could be excluded that would completely affect the jury that has been selected. I think that asking the jurors at this stage about a new witness is fraught with problems. And it doesn't change the preparation aspect in a case of this magnitude. And then in relation to Patty Johnston, she was a foundational witness, one that is really no longer at issue, and so we didn't elect to bring her up. Roma Henry is not a foundational witness. She's a very material fact witness that the state is seeking to call.
Your Honor, I said I'd bring all these documents up and neglected to do so. May I approach?
You've seen them?
I'm sure I have.
They're the emails and the pleadings that we've all been exchanging. Do you want to look at them first?
Sure. Sure.
The only thing I would want to say more, Your Honor, and I think I've said this already a little bit, but I think the clear analogy is to the rebuttal witnesses. The jury issue would come up there as well, but the rules clearly allow for the parties to amend the list of witnesses that they intend to call as the evidence develops.
If I could make one last thought, the other point that I think is significant is that from the state's point of view, testimony is largely cumulative. They have other witnesses that will testify about Mr. MacNeill's presence at the safety fair or lack thereof, and they have another witness that will testify about him wanting to get his picture taken.
Who is that?
David Laycock.
So, safety fair witnesses are whom?
Melissa Frost, David Laycock. Maybe Gayla Moore, did she say something about going to?
She did, before he went.
Before he went, yeah.
Who's that?
Gayla Moore is another developmental center.
What, I appreciate that. That's a new issue in terms of cumulative. What does the testimony of Ms. Henry add? How is it different than?
Yeah, Mr. Laycock will testify that the defendant wanted to have his picture taken, but what Ms. Henry adds is that she had a conversation with the defendant in which he repeatedly asked her whether he was in the photo and whether she wanted to take a different photo to make sure that he was in it, and that's something that Mr. Laycock's not expected to testify about.
Is Ms. Henry
as well as the fact that Ms. Henry is the one who actually took the photo.
Is that going to be in evidence?
It is.
Are there other witnesses, Melissa Frost, Mr. Laycock, who are in the photo, who could lay foundation for it?
I've looked at the photo recently, and I'm not sure I recognized it. I think there might be Melissa Frost in there, but I'm not sure for sure that it's her. It's kind of a grainy, dark photo.
Okay.
I don't think that...
So it's mainly this conversation between the defendant...
Yes, the value of her testimony from the state's perspective is the conversation that she had with the defendant, that to my knowledge, no other witness had, at least to the extent that Ms. Henry had.
When were you thinking of calling Roma Henry?
The reason we brought it up today, Your Honor, is that we were expecting to call her tomorrow. As I mentioned, Mr. Spencer and I had a conversation, an email conversation about this on Saturday. Mr. Grunander and I discussed it yesterday. I sent an email to Mr. Spencer to let him know that we still intended to raise this issue. We'd have the court decide it since we didn't agree. I wanted to raise it today so that if the court were to allow her testimony, Mr. Spencer would not be responding or reacting to that on the fly right before her testimony came up.
Okay. Can you remind me on the alibi statute, 77 what?
I don't have the notice anymore.
I think it's in my pleading that they,
Yeah, it'll be right there.
We got notice of alibi defense, but I don't see the statute cited. I just can't remember.
We're looking right now, Your Honor.
It's, I think in Title 77,
It's 77-14-2, Your Honor.
thank you. In what way will Ms. Henry's testimony contradict or impeach the defendant's alibi evidence? It sounds like it places him where he says he was.
Your Honor, we believe that, first of all, the USDC, as was testified today by Mr. Mickelson, is very close to defendant's home. And the theory of our case is that he was able to leave work, go home, kill Michelle, and return to work in time to receive that award. And that part of his being so adamant about being in the photo is his intention to establish the alibi. There's a picture of me here at work. And we think that part of our theory and part of our argument is intended to show that that insistence that he made on being in the photograph was actually part of the plan that he developed to obstruct the investigation and to establish that he has a false alibi.
Okay. Go ahead.
I'm sorry, may I speak?
Yeah, I'm sorry, I'm talking over you. Yes, go ahead.
I'm a fault for talking
No,
over you.
I know.
But the alibi statute requires that after the notice of alibi is served, that within 5 days, the prosecution must file a notice of additional witnesses, and that wasn't done in this case. I think that the alibi notion has just been raised in an effort to try and get around the failure to provide notice, but it actually, I think, hurts the state's argument here today because the rule requires that it be done within 5 days of our notice. That wasn't done. That's further support for why she ought to be excluded.
And when did that come in again?
September 17th, I believe.
Was your notice of alibi, and when was the state's first notice to you?
I would note, Your Honor, subsection 2 defines a continuing duty for both parties to continue to disclose additional witnesses as they come up.
Okay. Well, and it also says, as the court otherwise directs, 5 days after receipt of the list provided or at such other time as the court may direct. How could a question be posed to the jury that would adequately identify Roma Henry? Where does she live? What does she do? Does she continue to work at the developmental center?
Your Honor, she now resides in Antimony, I believe, which is a city south of us. I'm going to be meeting with her. Well, actually, I'm supposed to be meeting with her right now, but I'm not well acquainted with what she's done since 2007, so if I could have just a minute, I'll check with.
But in 2007, she was working at the Utah State Developmental Center?
That's correct. I've been told she has since retired since 2007, and it looks like she's been in Antimony for the past 3 years.
Where did she live in 2007?
American Fork.
Okay. All right. Counsel, what I would like to do is take this under advisement. I'll let you know in the morning before we get started what my decision is. I will tell you that if that any decision, it seems to me, would have to rest on some inquiry being made to the panel, to the jurors about whether or not they knew this person. I think that's the most weighty issue that's been raised by the defense. I'm not persuaded that the defense has been unfairly surprised, given that they have known about the substance of Ms. Henry's testimony since August of 2012. Although having said that, I will say that I would, even if I were to allow Ms. Henry to testify, I would feel uncomfortable having it done tomorrow. I think the defense does need to have some additional time to do what preparation it does need to do to prepare to meet the testimony. And I think I would, in all likelihood, order the state to put her down the witness list a little bit so that Mr. Spencer can have that time. I don't know how long that would be. My thinking is sometime next week. I do want to look at the cases that you've cited and also the statute, and I'll rule in the morning. Is there anything else tonight?
Not from the state, Your Honor.
Nor the defense.
Except
Very
for the
good.
tub, I'm assuming that's going to be gone tomorrow.
I'm sorry?
Is the tub going to be gone tomorrow?
Dr.
think
Van
Ada's-
Wagoner will be.
I don't think Ada's coming until Thursday, right?
It is coming Thursday, is that right?
Yeah, but can we have it pulled out for tomorrow so it's not sitting there all these days?
We're going to use it with Dr. Van Wagoner. He's our first witness up tomorrow morning.
Okay. I'm sorry, I don't understand the issue with the tub. Is there a problem with it staying here?
For us. Just didn't want to have the jury staring at it the whole time if it's not necessary is all.
Okay, well, so long as a witness is going to be referring to it during the testimony, I'll allow it to stay in the courtroom. But as soon as you're done with witnesses who are going to use it, let's move it out. I don't think it's not a big deal to move it, right?
No.
Okay. Although we can't keep it on this floor, I do know that. So there is some effort in it. Why don't you cooperate with each other and see if we can't reach an agreement about at what point in time it can be moved. Are you going to need it?
I don't know.
Not sure, maybe. Okay. Counsel, I very much appreciate your careful work today. Thank you. Court's in recess. Oh, I do have one other thing. Could you approach the bench?